I am Eric Jaffe. I'm the chairman of the Free Speech and Election Law Practice Group for the Federalist Society, which is sponsoring this panel on whether or not government should regulate the private regulation of free speech, not just government regulation of free speech. I'm here simply to say hello, to pitch the practice groups and tell you should join a practice group. They bring you wonderful programming like this on either free speech or some other topic if you were so silly as to want to do some other topic, but this topic. And they provide a ton of interesting opportunities for writing, for speaking, and things like that. So please, if you haven't already, join one of the practice groups, join our practice group, that would be great. I will introduce Judge Grant, and then she will take it from there and introduce all the panelists. So with us moderating the panel today is Judge Grant from the 11th Circuit, appointed in 2018. I would say that her list of prior positions is like a laundry list of separation of powers violations, maybe, really. She almost had the perfect double triple, but just is one shy, and you'll see which one it is. So in Georgia, she was counsel to the Attorney General, she was the Solicitor General, and ultimately a Supreme Court Justice. Missing, of course, the legislative branch in Georgia. At the federal level, she worked for a Georgia Congressman, Nathan Deal. She had several positions in the White House. And then, of course, she clerked for then Judge, now Justice Kavanaugh, which we all heard from last night wonderfully and inspiringly. All the rest of her background and detail that got her to all those wonderful positions you can read in the bio. I'm not going to belabor them, but I would like to say thank you very much, Judge Grant, and take it away.
Thank you. Thank you for the very kind introduction, and this is a great panel to be leading. I've heard some joking complaints from practice group members that they try to hide this group in the basement, but it looks like they've been found. So thank you all for coming to what promises to be a very exciting and interesting panel. As we know, this is about whether the government can, should, or sometimes even can regulate private speech and internet content. And this is one of the many areas where technology and the development of personal practices and technological needs has created some interesting ways of looking at the law and thinking about the law in ways that perhaps we hadn't imagined even 5 and 10 years ago. So what I'm going to do to give you the run of the show is I'll introduce each of our panelists in turn, and then each one of them will give you a 6 to 8 minute thesis, what their argument is about how the policy and legal interactions between these topic areas should be handled. And then after that, they'll have the opportunity to pose questions to each other to bring out some of the finer grained differences in their approaches. So I'll interject as necessary, try to keep this in mind. And then after that, hopefully we'll have a chance to get some questions from all of you. We're really appreciative of having such a great interested audience as well. So first, the first panelist to my right here is Professor Eugene Volokh, who's professor of law at UCLA School of Law, where he writes mostly about First Amendment and internet law. Seems like a perfect panelist. In 2012, he was commissioned by Google to co-write a paper on search engines' First Amendment rights to control their search results. He is speaking here, however, entirely on his own behalf. The next panelist, Ann Coulter, was kindly invited by one of our panelists who was unable to attend. And Ann Coulter is the author of 13 New York Times bestsellers. She's a legal correspondent for Human Events and writes a popular syndicated column for Universal Press Syndicate. She's also a frequent guest on many TV shows. She's a Connecticut native who graduated with honors from Cornell University School of Arts and Sciences, and received her JD from the University of Michigan Law School, where she was also an editor at the Michigan Law Review. She clerked for the Honorable Pasco Bowman II of the United States Court of Appeals for the 8th Circuit and was an attorney in the Department of Justice Honors Program for outstanding law graduates. After practicing in private practice in New York City, Coulter worked for the Senate Judiciary Committee, where she handled crime and immigration issues for Senator Spencer Abraham of Michigan, a friend of the Society. From there, she became a litigator with the Center for Individual Rights in Washington, D.C. Next is Professor Eric Goldman, professor of law and co-director of the High Tech Law Institute at Santa Clara University School of Law. Before he became a full-time academic in 2002, he practiced internet law for 8 years in the Silicon Valley. His research and teaching focuses on internet, IP, and advertising law topics, and he blogs on these topics at the Technology and Marketing Law blog. Managing IP Magazine has twice named him to a short list of North American IP thought leaders, and he has been named an IP vanguard by California State Bar's IP section. In 2019, he was the recipient of the University Award for Sustained Excellence in Scholarship, Santa Clara University's highest award for scholarly achievement. And last but not least, Adam Kandub is a professor of law at Michigan State University. He directs its intellectual property, information, and communications law program. Prior to entering the academy, he worked at the Federal Communications Commission and in private practice in Washington, D.C. Let's welcome all of our panelists. Professor Wallach, take it off.
Great, thank you. This is a subject that I've long been interested in. And does their PowerPoint all queued up?
Maybe try and point
Pardon?
towards the front.
Oh. Well, all right. Well, while we're waiting for it, the big picture here, I think, is something that I think as a good Federalist, I'm kind of torn on. On one hand, private entities should have very broad rights over their own property. And I think that's sort of my presumption, is that when private entities do things or exclude things from their own property, that should be their choice. And that's actually part of the diversity of power centers that happens in American society. That's, I think, generally quite good. At the same time, if you think about kind of the big picture First Amendment theories about search for truth and marketplace of ideas, democratic self-government, private power can interfere with participation in the marketplace of ideas, search for truth, democratic self-government, may not be able to interfere quite as forcefully or as monopolistically in a sense as the government can, but it can do it pretty significantly. So it turns out as a result that I think we have some interesting and difficult questions. I have some intuitions about how to resolve them, but I just want to kind of chart out some of the issues. So first, question that some people might ask is, does current law already ban viewpoint discrimination by platforms? Platforms would be things like YouTube, run by Google, but let's view it as separate, Facebook, Twitter. So I think it's quite clear there's no state action for First Amendment purposes. I don't think there are monopolies. If there were monopolies, there still wouldn't be state action. That's just a pretty solid doctrine, that even regulated monopolies are not state actors for First Amendment purposes, much less unregulated things, which I don't think are monopolies in the eyes of the law. Now, some people point to the Marsh v. Alabama doctrine. That's the famous company town case from the late 1940s, early in the free speech jurisprudence. In that case, the court said, well, a private company can't exclude people from the streets of its company town. But that's because the court's view is this is a town. Towns are traditionally run by the government. Speech on the streets of towns is protected. This town may be owned by this company, but except for that, it has all the characteristics of any other town. So it's essentially, it's been understood, Jackson v. Metro Edison is a more recent characterization of Marsh, as a case involving a traditional public function. That if you are a private entity and you run a town, then in that case, you are subject to the First Amendment. But being a platform is not a traditional public function to the extent it's analogous to what has been done traditionally. And I realize the analogy is imperfect, as all analogies are. It would be to a newspaper, which is not at all a traditional public function. But going beyond that, there is no direct governmental analogy. Now, there are these state access to shopping mall rules under state law. The classic example is prune yard doctrine in California. I think they're just preempted by federal law, both by Section 230, but also by the Commerce Clause. I don't think that a state can set up rules on these very much interstate, multi-state telecommunications companies. What about contract law? I think we'll hear a little bit about that. My view is if a contract promises continued rights to post, it should be enforceable. So if a company says, we will let you keep posting, and that's that. All right, deal's a deal. I've seen some cases that say that too is preempted by Section 230. I don't think that's right. I think contract law is enforceable. But the default is provider a right to control what it hosts on its own property. Just like by default, the property owner can tell visitors, sorry, you got to leave, unless it violates some, say, public accommodations law. But in the absence of that, it's entitled to do that. That's the default. I think that it would take an affirmative promise, a clear promise, to go against that default. And Facebook and YouTube, for example, try pretty hard to make clear that, for example, if we determine that you have repeated our community standards, we may suspend your account. YouTube even more clearly says YouTube reserves the right to decide whether content violates terms of service. So when it says you can't have harassing or offensive or dangerous or harmful or whatever else, it's up to them to decide. That seems to me as a private property owner choosing what to allow in its property and not promising the contrary. But the interesting question, it seems to me, is what if Congress says, well, we have a different view. We are going to implement an anti-discrimination, a viewpoint discrimination ban. Could be either a common carrier model or an anti-discrimination civil rights law type model. You may not discriminate based on viewpoint. My view, and I talk about it in the paper, but I'll stand by it as an academic too, that's in the Google white paper, is state laws can't interfere with editorial choices. And for example, the output of Google search, I just want to make sure the time is right. The output of Google search is an editorial choice. So Google, if Google comes out with a particular layout of things, it's just like an encyclopedia publisher deciding what to include and what to exclude, or a newspaper deciding what to include and exclude. So under Miami Herald versus Ternillo, I think that they have the right to make decisions about what to recommend. And that includes if Facebook or Twitter decide to say, or YouTube decide to say, we recommend this video. They can recommend what they want and refuse to recommend what they don't want. That's their choice, just like a newspaper editor's. But what about rules that platforms must even-handedly host speech? So it says, look, Twitter, you don't have to recommend particular Twitter feeds, but you can't cancel them. If somebody's built up a big audience on a Twitter feed, you can't then at some point say, nope, sorry, you can't do that. Regardless of what your contract says, we're going to ban discrimination based on viewpoint, just as we might ban discrimination based on religion or race or whatever else. I think that's a difficult question. My sense is, probably under existing precedents, like here I'm quoting from Rumsfeld v. Fair, which upheld a requirement that universities host military recruiters even if they don't want to, and concluded that would be permissible to impose just even as a flat rule, not just as a condition on funding. Similarly, under the Pruneyard case from the Supreme Court, under the Turner Broadcasting case, it seems to me that's probably constitutional. I think Eric might disagree. I'd love to hear from him. And it may be unwise. It may be a bad idea to impose these kinds of requirements. But I want to stress that this is a different question from the question of whether it's okay to restrict what people recommend, what these services recommend. Now, here's a question, though. Imagine there's such a statute, but Congress says, except we really like the fact that, for example, you try to block pro-terrorist accounts that seem to engage in ISIS recruiting. Not outright criminal, not just accounts that are part of a conspiracy with them, but accounts that praise ISIS and sort of or at least as best we can tell, they're not criminal. They just advocate for ISIS, but Twitter, YouTube, let's say, no, we want to distance ourselves from that. If Congress has to impose any anti-discrimination laws in itself a viewpoint neutral way, if that is the rule, then in that case, Congress has a choice. Either it has to leave full flexibility for the services to ban whatever they want, or it has to require that services allow everything. It wouldn't be able to impose this kind of rule, which would be a viewpoint-based rule. So one interesting question is when protecting speech. We know that when restricting speech, the government has to be viewpoint neutral. The question is when it's providing extra protection from speech from private actors, does it have to be viewpoint neutral too? It's an interesting question. There's some disagreement about this. I'm inclined to say probably yes, but I think that's an important thing to consider whenever we're urging Congress, let's say, or thinking about urging Congress to do that. The last thing I want to stress is employer power. This isn't something that necessarily the other panelists will want to talk much about, but I want to point this out because as important as the platforms are, if I tomorrow am kicked off of Twitter, let's say, my automatic Twitter feed, well, it's too bad, but I'll find some other way of conveying my message. If I'm kicked off of the Reasons website, not that they would ever kick us off, but if they did, which they have every right to do, then I'd find some other place to be. But if I were threatened with firing, as it happens, I'm a government employee, but what if I were a private company employee? I might think twice about saying certain things because then I'd be losing my livelihood. Now, it happens that about a third of the states and a bunch of cities and counties have actual rules that ban employers from, here's the California rule, from enforcing or adopting any rule that controls the political activities of employees. And political activities, the California Supreme Court in the gay law students case back in the 1970s says, connotes the espousal of a candidate or a cause. So it's not just partisan or electoral activities, it's any ideological activities. And in that situation, the court interpreted that as banning sexual orientation discrimination before any such specific sexual orientation statute was enacted, based on this political activity statute, on the theory that being out of the closet is itself, as well as advocating for gay rights causes, is itself political activity. So another question we should ask ourselves is, what should we think about that? Should we say it's yet another improper trammeling of private employer power? Or do we think that this is an important way of making sure that the search for truth in the marketplace of ideas and democratic self-government isn't unduly interfered with by private entities?
Thank you, Professor Wallach. Ms. Coulter.
I haven't practiced law for 20 years. I know nothing about the legal area, but I'm an avid social media user. And luckily, I think in this case, it doesn't matter, because this isn't a shopping mall. This is the movie Rollerball. This is a few corporations. It isn't companies like Twitter, like Facebook. It is Google, Facebook, Twitter. They control the discourse. It would be as if there were a few years ago, I saw a story about the guy who invented a way to force people to pay for the air that goes in their car tires. You know, at a gas station, they used to not know how to charge people for that. So, congratulations, thanks, jerk. It used to be free, but you made us pay for it. It would be as if somebody cornered a market on oxygen. This is how people communicate. Anyone over 50 may not understand this. There's no one under 50 who's turned on a TV. It's not enough to just say, go start your own Twitter. I mean, look at what happened to Gab. Gab tried to start an alternative to Twitter, it got its server taken away. It's got its bank taken away. It got taken off every app, every platform. These are monopolies on speech. It's like having a monopoly on air. It isn't a shopping center. And no, if you're thrown off Twitter, actually, it turns out you won't be able to come out with some other way to be heard. I mean, look at Milo Yiannopoulos, who was the biggest thing since sliced bread. He was making something like $800,000 a month on his YouTube videos through Facebook. Thrown off, deplatformed, depersoned. He's not on Twitter. He's not on Facebook. You can't find him anyplace. Gavin McInnes, the same thing. Laura Loomer. No, these people are all deplatformed. This is how we communicate with one another. I knew this would happen because I sort of wondered, you see the nostalgia for the three networks, especially during impeachment right now. Oh, if only we could go back to when we could remove a president. That was great. Remember when Dan Rather went on TV and said we were losing the Vietnam War? Those were the good old days. For a few years now, I've been wondering, how are they letting us have free speech? They've got to put an end to this. Well, yeah, they are putting an end to it. I know libertarians also make the argument that, but if you start a government regulation, well, then the Democrat comes in and regulates. No, I'm not suggesting new regulation. I'm saying this is a unicorn. This is like someone cornering the market on air, or if Alexander Graham Bell invents the telephone and instead of being a genius inventor, was also a genius inventor / left-wing dictator. When he starts listening in on your phone conversations, no phone service for, start your own telephone company. That's what we're dealing with now. It's not a question of regulation. I think you have to look at these three social media companies. And by the way, I have begged my friends in tech, create an alternative. That's whom I'd prefer to be talking to. Not that you're very lovely. The law is very important. But I'd like to be talking to MIT. I'd like to be talking to MIT geeks and asking them to start a Manhattan Project to come up with an alternative. I have. They say you cannot do it. It is too entrenched. Facebook, Google, Twitter. Google does have an excellent search algorithm. But it's more than that. Everyone is on Google. We can't get out of it. It isn't a shopping mall. It's a gigantic public square. We don't need somebody to regulate it. We have free speech rules. Just treat them like as if they're a government running a public square, because that is what they're doing, except they are more powerful than governments. They are like rollerball with 3 companies that are far more powerful than a government. They shut down Google. I mean, Twitter has said, oh yeah, if you weren't president, we'd ban President Trump. How does President Trump communicate? How does Ilhan Omar communicate? I mean, almost all of the news we get is from what people are putting on Twitter, and they just come along and take and Twitter's one of the better ones. They're better than Facebook and YouTube. And they come along and take down tweets, demonetizing one conservative platform after another. The power they have is stupendous and terrifying. And if you believe in free speech, it's just not enough to say, go create your own Twitter, or, I'll stand on the town square. Nobody's going to be in the town square. They're home on Facebook. Thank you.
Professor Goldman.
I think it was interesting Anna invoked the sci-fi dystopian movie of Rollerball. Actually, I think there was a movie about a monopoly on oxygen. I think it was called Spaceballs. For the first 20 years of the internet, we saw just a remarkable shift in the overall human condition. We saw the rapid growth and innovation of new technologies that provided services that make our lives better on day-to-day, hour-by-hour, minute-by-minute basis. I've been baffled by the shift in attitudes toward the internet, going from an environment where we love it and it makes our lives better to something else. And I've been trying to puzzle what's prompting that. And so I'm going to talk about 3 things I might be driving why we have a conversation like this, which we didn't have for the first 20 years of the internet. What's going on that's prompting these dystopian fears? Are we going to live in a rollerball world? I hope not. I think I would be smushed pretty quickly. And so let's talk about three things that might be going on here that's driving this conversation. One is the fear of bias. And I think in this room, I think there may be some people who subscribe to the view that the internet companies are biased against conservatives. And I think that there's a lot of ways to peel that back and disaggregate all the different norms that are baked into that fear. But we have to start with the terminology. We often hear reference to things like platforms, and platforms are doing this or platforms are doing that. What internet companies do, Google, Facebook, Twitter, if we want to focus only on those, is that they publish third-party content. They're content publishers. And every time that we shift the rhetoric from publication of third-party content, we actually are creating some weird dynamics in our conversation, because when we talk about publishing third-party content, we kind of know what the answer is. That's what we expect to be protected under the Constitution. The decision of what content to publish or not is like so basic to how we think about free speech that the only way we can really have this conversation, not talk how can we censor Google, Facebook, Twitter, is by shifting the rhetoric. So let's take the rhetoric back to where we start from. Bias against conservatives would be another way of saying publishers exercise their editorial discretion in ways that some people like, some people don't. And that form of bias is intrinsic in every publication process. In other words, what do publishers do? They exercise editorial discretion. When they do that, they prioritize some content and they deprioritize other. That's what it means to be a publisher. You cannot have neutral publication because a very act of publication is not neutral. It is prioritizing some things and not others. Now, Section 230, for those of you, I trust most of you are familiar with, those of you who aren't, it simply says websites aren't liable for third-party content. They can publish that content and not be liable for it. That law was really like one of the most pure codifications of a libertarian norm that I can recall seeing in the last 25 plus years. It says we're going to clean out a bunch of potential legal liability in order to create new opportunities for growth. And that is a key part of why we were in love with the internet for the first 20 some odd years, because it was creating new things that were making our lives better. Section 230 is what opened up the door for conservatives to have the voices that they wanted to have. You cannot have a bunch of the people who are now we would recognize as brand names, and Ann mentioned some of them. They would not have existed without having had the opportunity to have access to the services that let them publish their content. And so that entire flourishing ecosystem is actually due to the fact that we removed the legal constraints on the publication of third-party content. We are seeing a continued diversification of services catering to conservative voices and suggested that maybe Gab isn't going to be our solution, but there's a whole lot of innovation. I actually did a search before this talk about conservative social media, and I couldn't even count all the names. There's a lot of innovation going on in space. Why? Because Section 230 enables that kind of activity to take place by lowering the entry barriers and not holding those services liable for the fact that there's going to be people who are going to say some stupid things on them, as they do in all services. And whenever we talk about trying to tell people that they must carry content, that they're, the publishers are favoring one category of content over another, that sounds a little bit like the fairness doctrine, which was one of the doctrines that was a lightning rod for the conservative movement for years as a way of restricting the power of private publishers to decide what they thought was best for their audience. We got rid of the fairness doctrine, but I'm not sure that there aren't people who wouldn't support reinstantiating it for the internet. In 1997, the Supreme Court said that the internet was not like broadcasting. And so any of the regulatory solutions to broadcasting, like the fairness doctrine, just don't apply here. They're not appropriate for this community. And I do slightly disagree with Professor Volokh, which I don't like doing because he is smarter than me, and especially on constitutional law. So I'm a little nervous here. But taking away the power of a publisher to decide what to publish, forcing them to publish something they don't want for their audience, to me is a form of censorship. It is a violation of constitutional rights. I'm just going to mention two other things quickly because I'm sure I'm already over time. I do want to mention this issue about media consolidation, that there's too much power in too few hands. And I think if I understood Ann's remarks, that was the main objection that she raised. Unfortunately, media ecologies usually consolidate. That's not an unusual thing in media and industries generally. You see it over and over again, that they start out with a wild west where lots of people start, and then they roll up into smaller and smaller communities. That's a natural dynamic in this field. It's nothing surprising. But antitrust law still applies, and there's no reason to rule out the ability to constrain the behavior of monopolists who abuse their marketplace position, but only when they abuse their market-based position. Being big is not a crime under antitrust law. That's something where we look for something more, and that's an intrinsic part of the antitrust laws that we built up since the Reagan Revolution, and we should continue to embrace that. The last thing I'll mention is about there is, I think, at least among some people, fear of technology. If it's not about the power of Twitter to turn off someone's feed or YouTube to kick someone off and take away the $800,000 a month, it's that the AI is going to kill us, that the robots are coming for us and they won't value human life. Whatever it is, I do encourage us all to remember just how much technology has benefited us on a day-to-day, hour-by-hour, minute-by-minute basis. What you do on a minute-by-minute basis is usually fueled by access to internet services, and many of those internet services are in existence only because we have kept the law from squashing them. And so before we forget all the great things that are taking place in our lives, I want to just remind you that that we've got here because of the ability to keep the law out of it. And if we turn our corner on that, query if we're actually going to continue to see the benefits that we hope to get. Thank you.
Thank you. Do you need the technology? Great.
Yes, speaking of technology.
Professor Kandub,
Thank you.
last but not least.
Well, I'm not 5'5", so maybe I am least. But in any case, that did not work well. Okay, I'll think of a new joke.
You're a giant to us, Adam.
Yeah, exactly. Well, I am going to disagree with Professor Volokh, and we'll let the audience decide. I think that the notion that some sort of anti-discrimination requirement on the big media companies is compelled speech or would be prohibited by the First Amendment isn't true. I think if we had general sort of basic anti-discrimination rules governing the deplatforming of Twitter or Facebook, so they couldn't throw you off if you were African-American or homosexual or a member of the Federalist Society, this would be quite consistent with 200 years of American law. I mean, to this day, the telephone company can't deny you a telephone if you're a Republican or if you're a Satanist. Rather, they're common carriers. They have an obligation to serve everybody. And it also means so there's messages going over the telephone all the time that presumably Verizon and AT&T don't like very much. But for over 2 centuries, we've been having this regulation, and the First Amendment has never gotten in the way. People have accepted this as a basic part of what communication is. This is what Anna was talking about. Every society needs a place where we all can come as equals and converse. And it's not just common carriers. It's not just this tiny little group of industries. Rather, Turner Broadcasting. That was the old cable system ruling from the Supreme Court. And it's a little esoteric, but it involves requiring cable systems to carry the messages of broadcasters. Pretty compelled speech to me. Cable didn't want to carry it at that time, but the FCC said, yep, you got to carry it. And the Supreme Court said that was fine. That was fine to make a private company, Comcast, carry the messages of a small group of other private individuals. And if we take that as precedent, still good law, a non-discrimination requirement on a dominant platform like Twitter or YouTube, so they can't go after individuals, which is not content-based. It's more of a time, place, manner of restriction and serves a legitimate public interest, allowing people to converse equally on this platform. I think that seems to me to pass muster. Okay, and can you actually impose these sort of non-discrimination requirements on social media? If you're going to go so far as to classify them as a common carrier, which if you look at the statutory definition, and I won't go through it with you. It's I'm the last panelist, and it's getting a little it's getting long already. But I think you probably could. Now, would the FCC ever do that? I don't think so. I think we all know that the powers that be would send lobbyists, and they would, set themselves on fire in front of the FCC on 12th Street, and that would never happen. But if not common carriers, you could probably regulate them in the same way that cable television is. And again, a basic, mild non-discrimination requirement, so they can't single out people. They can't have a clear ideological slant. And finally, you could clearly condition non-discrimination on the special liability breaks found in Section 230. Professor Goldman spoke about them, but right now, internet platforms have a degree of immunity from liability that no newspaper, no television, no cable system has ever had in our history. That was a gift to the nascent industry by a grateful Congress. And that could be revisited and say, look, if you want this liability break, you have some obligations to forward a truly democratic public forum that we all can be part of. And just one more point about, it's not in the slides, but about something that Professor Volokh talked about, which is, is this like Marsh? Marsh was a public town, and the court said, look, there's some public rights of access that you have to recognize as a city company town. The company town couldn't restrict the citizens of the town from posting things and from I think it was religious proselytizing. And the idea was, well, look, if the private actor takes the job of the government, well, then First Amendment obligations come along. And Professor Volokh said, oh, no, obviously Twitter's not the government. But consider this. Every congressman has a Twitter account. Agencies have public meetings on Twitter. Our president has an account which has been determined to be a public forum in which he cannot legally block people from entering. If Google blocks you from, or deplatforms you, or YouTube deplatforms you, you can't, or Twitter, I guess, you can't go to these meetings and participate as a citizen. You can't go and comment and respond to President Trump. So in that sense, I think it's pretty clear that social media is becoming a sort of public town, a company town, and it's totally natural and appropriate that we consider rights of access. And finally, I'll just leave with some more sort of speculative ideas. Again, I'm taking issue with what Professor Volokh said. So he believes that Google expresses its editorial judgment when it gives you results. I'm not so sure. I mean, what does Google express? Does it express googliness? Does Twitter express Twitterness? Are the responses really that Google gives when you put in a search, is it really a editorial judgment, or is it simply like a Dewey Decimal System? It's a way of classifying information so you can retrieve it more speedily. The Dewey Decimal System doesn't, express anything. Now, even under Supreme Court precedent, remember, to be expressive, minimally expressive, we look to the Renton case, which of course involved, naked, nude go-go dancing. Maybe it's just me, but I find, nude go-go dancing infinitely more expressive than the Dewey Decimal System. I think that's an open question. Finally, even if it is an editorial decision, even if we grant that to Professors Goldman and Volokh, not all editorial decisions are protected from free speech. I mean, by the First Amendment. So, for instance, let's say that Google decided we're going to, downgrade all businesses owned by African Americans, or all Jewish videos on YouTube shall be banned. Well, that's our editorial judgment. It would seem to me, however, that civil rights and a bunch of other laws would take precedence. So, and finally, and I do have to say this, I'm disclosing at the end. I'm lead counsel in a case against Twitter involving a deplatformed individual, a very eminent feminist Canadian activist, Megan Murphy, who was kicked off Twitter, relying on Twitter's express promises in terms of use. And if anyone's interested, I have them up there if you want to go through. And Megan called Jonathan Jessica Yaniv a man. And Yaniv is an alleged sexual predator who became a public figure in Canada for suing female beauty salon employees for refusing to wax his still quite male personal parts. So we go around and actually sue these poor working women for refusing to do these services for him. Murphy, denounced him on Twitter, said this was a terrible thing to do, and called him a man. And she was kicked off Twitter for the crime of misgendering. We can talk, we can look at the contractual provisions if people are interested, but I will just conclude, and getting back to Anne's point, which is about the question of power. So there's a very eminent, probably one of the most eminent child psychiatrists, and his name's Paul McHugh, who pretty much says the same thing that Murphy did. He does not believe in transsexual therapy for children. He thinks it's ridiculous and it's wrong, and he doesn't believe that sort of thing. And he tweeted that. He was kicked off. Now, there was sufficient outrage from he's a professor at Johns Hopkins, there was sufficient outrage that he was put back on. But Megan Murphy, who's just, is just an activist in Vancouver, who said pretty much the same thing, no. So what we're getting in the social media is the very opposite of a democratic discourse. We're having a conversation of the powerful and the well-connected. And I think that's profoundly destructive for our democracy. And that's it.
Thank you. We've heard definitely 4 interesting perspectives, and although I've got plenty of questions of my own, I think it would be unfair if after promising the panelists that they could question one another, I jumped in. So does anyone have a particular question that they'd like to ask one of the others?
Could I ask a question of Eric and a question of Adam? So Eric, so I appreciate your argument. I think I agree with much of it, but I wonder about this argument that the platforms are publishers as to everything. So just take an example. As I understand it, Gmail has never said, oh, or Google has never said, oh, if you use Gmail for hateful purposes, we're going to cancel your account, right? And I take it if they did that, there would be a lot of outrage, and there might be a call for Congress to say, look, if you're providing email services, you can't do it in a viewpoint-based way. Now, you could argue as to whether that would be a good or a bad call, but I take it we'd say that Google is operating as a platform, as an entity that distributes others' material like a phone company does, and that is therefore not within its there's not a First Amendment violation with requiring even-handedness with regard to email. So what I'm wondering is, why wouldn't the same apply when YouTube simply provides space for people to host things? Why isn't that indeed closer to Turner Broadcasting than to the Fairness Doctrine? Recall, one of the problems with the Fairness Doctrine is it did restrict the speech of the television stations. It deterred them from posting certain things because that would trigger right of response. It took up time that they would otherwise like to use for posting other things. And that's what the problem with it. But in Turner, when it came to a more content neutral mandate, that seemed okay. What do you think about this hypothetical law that bars email services from discriminating? And if you think that's permissible when it comes to their restriction on one-to-one people's speech, why wouldn't it be okay to have, constitutionally okay, whether or not a good idea, to have a similar law when it comes to platforms operating as just hosts? And for Adam, I want to ask a separate question, which is, if Google search really is like a company town and subject to First Amendment rules, then it would have to be content neutral and not viewpoint neutral. Google search that's content neutral would be useless. Obviously, we want Google to select things that are matching content, but not even just, well, we insist that it would be the algorithm that just counts the number of references, right? If I post something that says, how old is the Earth? It's actually a useful service to me if Google tells me 6 billion years rather than 6,000 years. So if indeed Google were governed by Marsh v. Alabama, again, as to its recommendation, as to its search function, not as to its hosting function, wouldn't that be would damage a lot of its qualities, which makes us think that maybe it is engaging in expression the way that an encyclopedia publisher, even though the Britannica may not be conveying a message of Britannica-ness, is importantly selecting things that it thinks are worth passing along and not things that are not.
So just for the audience here, I think you've just seen firsthand what it's like for a law professor to cold call another law professor. I can assure you that that was not planned, and I'm a little stressed here about answering Professor Volokh. Professor Volokh gave actually 3 different examples, and it shows the difficulty of keeping our conversation straight when we're talking about media. He gave the example of email as a service, cable broadcasting as a service, and then web publishing as a service. And each of them have different technological and legal foundations that could lead to different constitutional conclusions. So, for example, when you have email, it is illegal for the email service provider to read the contents of the email. So if someone's sending an email filled with the most hateful content, the email service provider should be agnostic to that. Now, having said that, if the email service provider gets complaints about that person, that they are consistently engaging in wrongful behavior, in fact, the email service provider might very well turn that email account off and might be expected to turn it off. Section 230 might say they're not liable if they choose not to do so, but they might still nevertheless decide that it's in everyone's interest to turn that account off. Not because they read the email, but because it is clear that their email account was being abused for wrongful purposes. So email is its own unique category, and it has its own unique dynamics about what is permissible and what isn't. Cable broadcasting has been treated analogously to over-the-air broadcasting in some respects. I will point out the Hollick case actually I think does some serious violence to the standards about Turner and otherwise, basically saying if it's private property, it can't be commandeered to require them to publish content they choose not to publish. That was just from this last term. So from my perspective, I think that we're getting some pretty strong signals from the Supreme Court that even in the context of cable broadcasting, they are not required to care everything that that legislation might require. And then the analogy to YouTube and to web publishing is to me like apples and oranges. We don't have a model of cable broadcasting, over-the-air broadcasting to refer to. We have this whole new thing where users are given the power to reach a global audience through the provision of a publisher that says, I'll take whatever you submit, subject to some very light rules at the outtake and subject to some back-end rules I might enforce. So that's a whole new category. And that's what the Supreme Court said in the 1997 Reno versus ACLU case, which said that the internet is a wholly unique medium. We can't look to the rules that apply to broadcasting and extrapolate them to the internet because the technological dynamics are different. We have something new that we've never seen before. And the Supreme Court said in 1997, there is no basis for qualifying the level of First Amendment protection for publication of content on the internet. So it isn't like broadcasting where there has been circumscription of what obligations and rights a broadcaster has. The court said this is not that. And as a result, I think that when we try to lump together email, cable broadcasting, and web publishing, we're putting three things together. Professor Bullock, did I pass your question?
Thank you.
Would anyone else like to weigh in on that one before we move to the next question?
I'm sorry, there was a question for...
Right.
Oh, yeah.
I'll take that as a no.
Yeah. Okay, so the question was, what use is content neutral search, and that therefore, obviously all search has to be somehow content based or have some sort of content proponent element, or just wouldn't be interesting. Well, I think to answer that question, which is probably correct, I think that's a correct observation, you have to look to where the question was asked. The question was, is Google expressive? And well, whether it's content neutral or content based is not exactly the answer to that question. Of course, it is expressive to some degree, but you are able to point to some idea, some notion that it expresses. Professor Volokh suggested, well, it expresses, the true age of the Earth. It's a kind of mild type of expression. It expresses correct answers. It expresses Google's best guess of what you think. Well, the Dewey Decimal System also expresses its best guess as to what you want when you're looking for a book. So that I'm willing to accept that Google has some sort of basic level of expressiveness, but then you have to ask the next question. Does that even minimal level of expressiveness warrant First Amendment protection? Or if it's less than that expressive, it doesn't get that much First Amendment protection, and then we're off to the races as to how we can regulate it.
Thank you. I think we've got time for one more question from a panelist, and then we'll open it up for questions from the audience. So please be thinking about your brief questions that quickly end with a question mark while we hear one more from all of these folks.
If possible, I would take that. Okay?
Yes,
Yeah.
please.
This is a question primarily for Professor Kandub. The New York Times has long had a motto that says, all the news that's fit to print. But I'm sorry, you're already getting laughs. I haven't even told my punchline. A farmer and a doctor walk into a bar. Okay, but we know that's not true. Everyone knows that that's not true. It's all the news that the New York Times concludes is fit to print, which is a very different statement than all the news that's fit to print. Do you think that the New York Times should be liable for the fact that it has claimed all the news that's fit to print? And if effectively what the internet services who are publishing third-party content are saying, we will publish all the user content that we think is fit to print, would that be different?
It's hard to answer that question. I don't quite understand it, to be honest. We all know the New York Times prints only that news, and precisely that news which it believes to be fit to print, and it does make editorial decisions. What are Google's editorial decisions? I mean, I guess to answer that question, we'd have to know what they are, but they won't tell us because all of the algorithms are secret.
But could I also say, I think it kind of misses the point. I don't care if Google goes around bragging, saying we're not crossing the creepy line. That was the big thing with them. And we all think they are crossing the creepy line. We don't care what their motto is. They can say we allow everyone, we arrange our search engines so that only the truest answer comes to the top. But if we care if they're not doing it, and if they're discriminating on the basis of not liking, well, certainly it's very obvious, not liking people's politics. I mean, years ago when Google first started, Rush and Drudge pointed out to me, you search our names, Ann Coulter, Matt Drudge, Rush Limbaugh. The first 10 results are, Ann Coulter is a C-word.com. Rush Limbaugh is a C-word.com. Matt Drudge is a C-word.com.
Or different one for different
They mixed it up a little. But it would be like a whole page before you get to our official web pages. Now, come on. Come on. You're not going to give the Drudge report? I think that gets more hits. I mean, I'm not really sure what to do when you're talking about search engines rather than them banning content speech. But I would think a first step would be at least for Google to release its algorithm so we can see it. Right now, it only comes out secretly when Google employees go to the Daily Caller or Breitbart and say, oh yeah, we were told to blacklist your site. We were told to blacklist Michelle Malkin. This isn't a shopping mall. It isn't the New York Times. You didn't have to subscribe to the New York Times. There were lots of other newspapers. There was local news. There was national news. There was Standing on the Street Corner. Now you have 3 companies controlling 90% of all communication. There is nothing like this.
Questions from the audience? I think we've got microphones around the room. It looks like you were up first.
Sure. My questions are a two-part question principally directed to Ms. Coulter. As a conservative, I'm quite conscious of how norms that are liberty enhancing when applied to the state restrict liberty when applied to the private sector. And so I'm struck by just sort of the strength and the with which you're arguing that these norms should be applied to private speakers. But let me ask you then, do you think that the FCC's abandonment of the fairness doctrine, which was unanimous in 1987 and roundly criticized by not just conservative and libertarian scholars, but scholars across the spectrum, was wrong? And what gives you confidence that the government can neutrally be an arbiter of neutrality? I mean, is President Warren's FTC going to be a good arbiter of whether somebody was wrongly given too low of a search response on Google?
Thank you.
Because we have 200 years of First Amendment law. No, I'm not suggesting the FCC start regulating things or bringing back the fairness doctrine. I'm saying that these 3 entities control 90% of all communication. They should be treated like the public square being operated by the government. And except obviously there's no time, place, or manner restriction. You're not going to be bothering anyone if you tweet at 3 a.m. It's not like, foghorn or something. So, but we have rules for these things, and the courts have developed it. And yet somehow we're all still living in freedom.
Next question over here.
So I suppose I have a question on the opposite end of this. So Ms. Coulter suggested that you should treat these entities as if we're treating the government because they control 90% of the traffic. But what about kind of the opposite, with a couple of decisions coming out of the Southern District and then Second Circuit holding that, for example, President Trump can't ban users on Twitter? And it seems somewhat odd to me for the following reasons. So Twitter could ban someone for being essentially abusive. Forget about, misgendering, but like outright abusive, right? But a politician to whom you're being abusive and not necessarily contributory, under those decisions can't ban it. And that seems, now I understand the difference between private entity and public, but not us, that seems somewhat odd. It seems odd from perspective, especially, and I suspect it would hurt women and minorities more than anybody else, but also seems odd that you actually then can't get your message out if somebody's spamming you with abuse. So any sort of views on those decisions and how that will eventually play out?
Looks like
Well, Eric, you want to go?
I'm sorry, I do need to challenge your factual premise there. The Second Circuit case made it clear that President Trump banned the speakers just out of because he didn't like what they were saying to him, not because they were abusive. That question hasn't been litigated in court. So your factual premise isn't supported by that particular ruling. We don't know what will happen in the situation you described.
But, I think the broader point, I think, is an interesting point. It's not a terribly practically important point. Actually, not much rides on whether politicians can or cannot ban commenters, in part because commenters can easily just sign on with a different account. But I think the analogy, and I'm not sure those decisions are right for other reasons, but I think the analogy is, imagine that the government rents space from a private entity. Let's say it wasn't President Trump. Let's say it was actually a government entity rather than just a politician who may have a private hat. This is a school board which has no private hat, but it doesn't have space, so it rents space in a church or rents space in the local Lions Club. The club could kick people out for whatever reason, at least unless it's promised not to do so in the contract. But it doesn't mean that when the government is using that private space, it can then decide whom to include or exclude. So I think the sensible point behind those decisions is when the government is making decisions about viewpoint-based decisions based about what goes on property that's within government's control, even if ultimately somebody else owns the fee simple right, that is subject to First Amendment scrutiny. That seems to me to make sense.
Thank you. Next question.
Hey, I'm Hans von Spakovsky, and my question is directed to Professor Goldman, although I'd be interested in what all the panelists said. Look, you gave a very vigorous defense of Section 230, which in essence gives government the equivalent of governmental immunity to the big platform providers. But the big platform providers lobbied Congress for that provision because they argued that they were not publishers. You consistently refer to them as publishers. In fact, what they said was, we're only distributors of content. If, in fact, they are now acting as publishers, they are exercising editorial control by deciding what they're going to publish and what they're not going to publish, why should they get immunity from libel laws? Other publishers, publishers of books, publishers of newspapers, who exercise the same kind of editorial control, they're not immune from libel law. Why should they continue to have that immunity?
Thank you for the opportunity to talk about that. Just factual clarification, Google, Facebook, and Twitter did not lobby for Section 230. They did not exist when the law was enacted. Right. And in fact, they exist because the law was enacted. So they were the beneficiaries of other people who thought it'd be a great idea to have this particular liability scheme, not the proponents of it. Your question basically gets at the heart of everything we do in internet law. I've been teaching internet law since 1996. This is what I do in every single class. We start with a fundamental question. Is there some reason to treat the internet different than other media? Is there something unique, special, or different about how the internet is constituted, about how it operates, that it may be beneficial to treat it as something other than other media that we could analogize it to? And in some cases, the answer is clearly no, that the internet is just like other media. It should be subject to the exact same regulations as other media, and I would support that. What we learned from the Section 230 experiment is that there's certain classes of content that exist only because we have a different rule on things like defamation for the online environment than we do for the offline environment. In other words, these classes of content didn't exist in the offline world because in part of the liability scheme that suppressed them from emerging. The primary example of this is something like consumer reviews. We never had an offline analogy to consumer reviews because they were litigation bait under the existing law. With a different liability scheme, we can create a whole new class of content that makes marketplace better. We also have things like online marketplaces. We have a variety of online marketplaces that did not have any offline analogy. They exist because Section 230 allows them to configure their market way, not take liability for the transactions that they enable, but to make those marketplaces more efficient. And the last thing I'll point out is something like the YouTube videos. The better example is something like the how-to videos. You can literally look up how to do anything on YouTube and find out an answer. It might be wrong. It might even be dangerous, but chances are you're going to get information that's going to help you solve your problem. There were no how-to videos available to you as a consumer in the offline world. We also didn't have the same degree of cat videos, but that's maybe not as socially important.
Yeah,
I don't think that's true. If you had, I mean, I think the question is an important one. Either you're a publisher, either you're the New York Times or you're a bulletin board. If you have a public square and someone is allowed, and it's the government is allowing you to go and stand on your soapbox, and someone stands up and engages in open legal defamation, okay, you have a lawsuit against the person who defamed you. You don't have a lawsuit against the gardener in the park or the person who is cleaning up the park. That's just the park that's open. It's the air. Because we're not publishing this. We're allowing you free speech in this park. If the park is deciding, well, these people can talk and these people can't talk, then I think you do have a right to sue the park for saying that, you've just been defamed. You can't have it both ways. We're just a bulletin board, and I'm all for it being a bulletin board. Nobody hates the internet. We love the internet. We're very upset that only certain viewpoints are being banned and discriminated against on the internet.
Yeah, and if I
Professor
just
Goldman, I think.
you go ahead.
Or could you, Bedman? Sorry.
Yeah. Well, first of all, it wasn't Google, YouTube, or Facebook that lobbied it. It was CompuServe and Prodigy. So it's not as if 230 was some sort of natural effusion of the public discourse. It was a giveaway to a certain industry. It was, as we mentioned, it was very generous giveaway. And that's one of the real problems with the current legal arrangement, because they're able to play a sort of jujitsu. When they want First Amendment protection from various laws or regulations, they say, oh, all this is expressive, just as Professor Volokh was saying. Our search results are the inner soul of Sergey Brin. But when we're on Section 230, which only immunizes comments and content from third parties, oh, we're just a platform. We don't have any control over what other people say. We can't be liable for these third party comments and content. So, the question is not, oh, this is a wonderful system and allowed us to have, how-to videos. The question is, we need a consistent liability regime for, as Anne said, the central engine of communications today.
So I want to agree in part with Anne and Adam, and in part with Eric. There is ample precedent for absolute immunity against libel liability for what we might loosely call platforms. Long before the internet, it was black letter law. You couldn't sue a telephone company for allowing libelous communication. So the cases in which it arose is there was somebody who had a libelous outgoing message on an answering machine, and somebody demanded that the phone company cancel that number. And they didn't, and there was a lawsuit, and the court said, look, phone company isn't allowed to cancel it. It is a common carrier, therefore it gets immunity. Likewise, as I understand it, under FCC rules, or maybe even under statute, broadcasters had absolute immunity over libelous statements in candidate ads, because they were required by law to allow candidate ads. Likewise, the park, the city that owns a park has immunity from libelous statements said in the park, because under First Amendment rules, it can't exclude people from the park, generally speaking. So in fact, before Section 230, there was this tradition of absolute immunity that was tied to non-discrimination obligations. So in that respect, Anne and Adam are actually arguing for a return to pretty traditional notion. But here's what happened in the mid-1990s. There were actually a couple of court decisions that seemed to point in exactly that direction. So what they said is, if you host online bulletin boards and you are non-discriminatory based on content, then in that case you get immunity. But if you host these bulletin boards, or I shouldn't say a couple, one case in particular pointed in that direction. But once you, as an entity, I believe it was Prodigy, once you... CompuServe. Was CompuServe? Yeah. I think CompuServe. Stratum B. So once you actually say, we're going to have some sort of content moderation, then you get stuck with liability. So the sense was, as a result, online platforms would be deterred from providing content moderation, which people wanted. People wanted those platforms to restrict vulgarities, to restrict maybe pornography, to do various other things. So it's a deliberate choice by Congress to promote content selectivity of some sort by making sure that the content selective entities, like the content neutral entities, both got the same kind of immunity. So it may be time to revisit that, but it's important to remember that there was a deliberate congressional judgment that we want to have some kind of content selectivity. And the question is, are we really prepared to mandate content neutrality?
Yeah, if I could just jump in, I think that interpretation of the 96 Act is a bit retrospective. This was 1996. Not many people were using the web. The World Wide Web Protocol was only introduced in 1995. The Section 230 was introduced as part of the Communications Decency Act. Does anyone remember what that was about? It was about banning pornography from kids, and it was pretty much all turned down by the Supreme Court. This was not a desire by Congress to have monopolists become content moderators, our friendly content moderators. This was really a desire by Congress to give some liability protection for people who wanted to get rid of porn. And I think that's obvious from the statute. It was not a desire, a democratic desire to the people of America saying, moderate me, oh, internet giants. So.
I think it's time for the next question.
Hi, this question's for Professor Goldman. So one of the most remarkable things I've seen in recent years is there are journalists on Twitter asking at Jack Dorsey to ban their political opponents. You see the same people writing op-eds demanding that Mark Zuckerberg censor their opponents. So, this is truly remarkable. It's clear that the power to control speech is now in these select few people's hands. They can make and break people's careers, livelihoods, reputations. And so at what point do you think that this power becomes too concentrated? Is there any point for you at which this power is concentrated in too few hands and used for sufficiently abusive ends that would justify government action? And if the Constitution's not a suicide pact, then certainly the First Amendment isn't a pact against free speech.
Thank you, Professor.
So let's just start with our terms. It's fine if you're concerned about Twitter, Facebook, Google because of the disproportionate share of our minds that they occupy, but they are a small fraction of the overall activity that's taking place on the internet. And one of the ways that we can get ourselves in a lot of trouble is to equate the two, to treat Google, Facebook, and maybe Twitter as if they are the internet, because there's so many other services that we use on a day-to-day basis that make all of our lives better. And you might be a Twitter aficionado, and so what Twitter does is it rocks your world. But there's all kinds of communities out there that you're not a part of that are benefiting every single day by the Section 230 and the First Amendment, and are in competition with each other to try and find a way to best cater to their audience. Those of you who are knitters, there's like a whole world of knitting that's taking place that maybe I'm not a part of, but boy, that's really important. That's worth fighting for. So we have to be very thoughtful about distinguishing what we feel about the internet from how we feel about Google, Facebook, and Twitter. Now, with respect to them, honestly, if you were asked Twitter, they'd say, we're not as big as Google and Facebook, so thank you for treating us as if we're equal to them, but we wish we had a small percentage of the revenue and profits that they generate. We have antitrust laws, and antitrust laws apply to publishers just as they do to everyone else. In fact, we've literally given exemptions to publishers from antitrust law where we thought it was better for them to coordinate their actions than not. The antitrust concerns here are really, I think, we don't have any foundation for the antitrust concerns. What we're really hearing is we're afraid of them because they are big and because of the power they have. Now, this is nothing new. Go read all the media literature from the 1970s. In every local market, there was one and only one dominant newspaper that controlled everything that was read by the community members. That their power went up to the Supreme Court in the Miami Herald versus Tornillo case, where the legislature tried to require the publication of content in this one single newspaper that dominated the local metro area. It was the way to reach the audience if you wanted to reach them in print. And the court said, I know that there's only one dominant player in the market. They are the monopolist in that market. We still cannot circumscribe their First Amendment protections of freedom of the press. So we have to recognize if there's an antitrust violation, we should deal with it as such. Every other form of power and consolidation taking place in media is a well-known phenomenon. It always leads to people complaining about that power, and we still don't get the right to circumscribe that publisher's constitutional protection because of it.
If I could just say, I think you're correct. I think for conservatives, we have a choice. We can sort of attach ourselves to what I would consider somewhat esoteric views of the First Amendment that, seem consistent with the early writings of Robert Nozick, or we can adapt a view of the First Amendment that actually protects public discourse and is not waiting for some antitrust suit that will never come to allow people to speak. I think we all know who dominates public discourse. We all know who is really speaking to young people and is changing minds. And I think if we want to have a seat at the table, if we want our ideas to have any chance, we have to make sure that these companies get their feet off our necks.
Well, Adam, so let me just ask you this. Would you have been in the dissent in Miami Herald v. Tornillo? Because those arguments really are, on this I agree with Eric, those arguments really are the arguments that until newspapers almost went out of business, the arguments that were routinely levied with regard to newspapers that really had kind of dominant power in any particular
Adam,
municipality.
could I interrupt?
Please.
Yes, please.
I'm sorry, this is an insane comparison. First of all, you may talk about the internet, Twitter, Facebook, Google, nobody really, they do much. Yeah, okay, they're probably shopping on Amazon or looking at porn. Nobody cares about that. We're talking about free speech, political speech. This is how people communicate politically. Ooh, Miami Herald. Ooh, they were so dominant. I'm sorry, in the 1970s, they had radio, they had TV, they had telephones, they had penny savers. There is nothing that can compare to Facebook, Google, Twitter, which owns, YouTube and the rest of them. There is no comparison. It's silly to talk about, a one newspaper town. It is absolutely silly to make any comparison to that. And I am sure everyone under 50 in the room knows that. That's for those of you over 50.
Any further comeback? All right, looks like we've got next question.
Yes, I mean, hearing this conversation actually makes me feel like all of the campus free speech conversations we have apparently mean nothing, because apparently none of that is happening. All conversation happens online. But my question basically is, I mean, we are at the Federalist Society convention. We literally have a copy of the Federalist Papers 2 floors above us right now. I'm not hearing any originalist argument either for the application of the First Amendment, which begins Congress shall make no law, to private parties, or to even permitting the government to engage here and start restricting the content that these private parties are providing. Would anyone like to make, maybe begin with the Prager lawsuit, right? Is there any originalist argument, or are we basically just saying, we are comfortable in this context with a living Constitution argument?
So I've actually done a little bit of writing about original meaning of the First Amendment. There's some stuff you can squeeze out of that, really quite little. It's not an accident that the country was quite bitterly divided 10 years after the First Amendment over a simpler question as to whether it's permissible to ban seditious libel. Now, to be sure, that was actually, the Sedition Act was an advance in many respects over older rules. Its backers were right about that, but there was a lot of dispute, in part because framers agreed that they liked freedom of the press. but it wasn't at all clear exactly what freedom of the press meant, even as to the relatively familiar technologies of the time. Not saying that's true as to everything. It may very well be that as to jury trial rights, people have actually talked about and thought and experienced jury trials all the time, day in and day out. So it may be that you can get a lot of originalist information about particular things. It's not an accident that, setting aside a few opinions by Justice Thomas, and they really are even a small part of his own free speech work, it's no accident that the Supreme Court basically almost never relies on really originalist arguments to free speech. Maybe that's a mistake, but that's been the reality from the left and the right. This is one of those areas where there's a lot of precedent, and I don't think it's going anywhere based on original meaning analysis, except maybe in the opinions of Justice Thomas, and that even very rarely.
If I could just add a bit of historical esoterica. I think the founding fathers were very comfortable with media regulation and sort of the ensuring equal platforms, and that would be the Postal Service. So one of the first acts of Congress, of the first Congress, was to put, I guess some constitutional lawyers would say, discriminatory rates that would favor newspapers. And it was very specific. If you were a newspaper, you got a special rate. That viewpoint discrimination, they still have it. But it was sort of, and also in really until the 19th century, the federal government did not run most of the postal system. It was really they ran large routes and then contracted out to local providers to do the rest of the work. And when they contracted out, went with them were anti-discrimination requirements. So just simply because you're a contractee of the government but a private person, you couldn't decide whose letters to carry. Now that could be a contractual issue, not a constitutional issue. But I do think it speaks to the founding fathers' belief that we need some sort of platform, a communications platform to bind the nation together. You don't like that, okay.
Thank you. Next question.
Well, in case you thought you didn't have to worry about campus speech controversies, you should just take into account the fact that the very people shutting down speakers on campus are graduating and going on to write the very terms of service that all of these Silicon Valley companies are using. So it is worth worrying. Professor Goldman, you asked a few questions ago a sort of general question about what makes these companies so worthy of specific attention. And in Section 230, what it says, part of what it says, is that the internet and other interactive computer services offer a forum for a true diversity of political discourse, unique opportunities for cultural development, and myriad avenues for intellectual activity. Now, if the explicit reason for granting Section 230 protection is that these companies are expected to uphold political diversity, then once they start defaulting on that, why should we be expected to, as the people, uphold our end of the bargain and continue granting them protections that no other publisher is given?
Thank you.
I want to give you a compliment here. I've thought a lot about Section 230, and that's actually a new argument to me. I've never heard anyone argue the point that you just made. So kudos to you for that.
Can I just interrupt and say, if a judge were to say, oh, that's a new argument, that's actually a pejorative. But when a law professor says that's a compliment.
I'm sorry, I really did mean it as a compliment, not
it is,
pejorative.
it is. No, no,
Okay, good. You guys all got that. Because you'll know when I'm giving you a pejorative, and it won't be subtle. So I want to take you back to what things were like in 1996. The idea wasn't that there was a vertical integration of all political diverse viewpoints in a single site. The idea behind Section 230 was to let the marketplace flourish with lots of different sites catering to different audiences. So the language that you quote was not about trying to integrate it all in a single company, but to make sure that the door was open for the full range of the human condition being expressed in different services catering to different needs. And that still remains true today. And if you want to say all the actions on Twitter, that's your view. I understand that. I don't agree with that at all, because there's lots of action taking place throughout the rest of the internet. And Section 230 is what's keeping open the door for those other services to enter the market to cater to the audiences that they serve. So that's how I would read the language. Thank you for raising it.
I'm interested in the way that the debate over net neutrality plays into what everybody's been saying here, because, when I listen to Eric, and I think find very compelling a lot of the arguments that you made against imposing common carrier viewpoint neutrality regulations on platforms. They sound to me extremely similar to the whole panoply of arguments that are similarly made against imposing common carrier bit neutrality, net neutrality regulations on backbone providers. So I'm wondering, I don't want to just pile on Eric, but I mean, everybody on the panel, I'm curious, do you come out the same way on both those questions? If you're against common carrier regulation for platforms, are you also against net neutrality regulation? If you distinguish them, I'm curious to know how you reconcile distinguishing the two.
Yeah, I appreciate it. I know that my colleague, Professor Candube, is going to want to speak up on that as well. He has a new paper coming out on that where he makes arguments to try and explain and I think ultimately eliminate what could be perceived to be a dichotomy. I will tell you, I find net neutrality a very hard topic and one I actually haven't taken a position on publicly. I've done 3,000 blog posts. I've never actually done a blog post on net neutrality because of the fact that I do find it such a difficult thing. On the one hand, to the extent that companies are moving data, they're contributing to conversations in our society, they're publishing content that should be protected as free speech, and therefore net neutrality obligations would be an incursion on that. The problem is, and this is what Professor Volk and I were having a colloquy about before, that trying to take rules that are built for one medium and extrapolate to another might not work. And for those who are familiar with the notions of the internet as a set of layers, where there's a stack of different services, they're all bundled on top of each other, anywhere from the transport of bits to the actual content that's being expressed, the different layers have different marketplace dynamics. And those marketplace dynamics might suggest that actually they should be treated differently accordingly, that we wouldn't want to treat the person who's moving bits the same as the person who's actually trying to express a viewpoint. It is awkward to talk about net neutrality because we have to confront the marketplace dynamics of the market for internet access. I'm sure there are people in the room who think that marketplace is competitive. I do not agree with that assessment. And in a marketplace that is so constrained by government regulation, that has in most markets a duopoly, that is a wildly different circumstance than what I see as the internet. Now, I think I don't mean to speak for you, but I think you're saying there's not even a duopoly. It's just monopoly, monopoly, monopoly in three different categories. So if you feel that way, then you would lead to the conclusion, well, we have the same lack of competition in the marketplace. That's not how I see it. And therefore, it might be that we would want to regulate net neutrality different, that we would choose the, quote, content neutrality analogy just because of the marketplace differences.
Professor Candube, what about you?
Yeah, so I do just want to point out, Eric, or at least that side of the table, that, in Tornillo, there's only a monopoly of newspapers, but you don't think there should be access. But if there's in the last mile, there's only two access providers, then maybe we should have some sort of regulation. Network neutrality is related to all of this stuff in the sense that if there's a First Amendment right, absolute right over the wires of the dominant communications networks not to carry anyone else's messages, then that goes to network neutrality as well. But by that same token, if you're going to take the First Amendment to that end extreme, we wouldn't have a phone network. I mean, we wouldn't have the basic building blocks of information require to some degree mandatory interconnection, which in turn requires some degree of compelled speech broadly construed. And I think what's good for the goose is good for the gander on both sides.
Next question.
So my question is something that panelists I think have touched on but not really dug into. Professor Goldman was saying that Google perhaps constitutes a small part of the internet, but I think most people in this room would agree it's how you access the rest of the internet. If you want to find Ms. Coulter's site, you Google it to try to get there. And if there's 10 results that are coming up first instead of what you're searching for, that seems to me a problem. And I wonder to what degree we should view Google as perhaps different than Twitter or Facebook, who at least nominally provide terms and conditions. You will be blocked for XYZ, when Google has an algorithm that is essentially gatekeeping the rest of the internet.
So I should say, I love having my computer up here. I Googled.
We complained about it and they stopped
So
it.
I appreciate it. I Googled it, and Coulter, and rightly so.
I absolutely was not this way 10 years ago. Rush and Drudge started making fun of Google for it. I think Rush was talking about his radio show, no longer true. But I will tell you, when you make a search for something on Google, I've looked for statements that I just read, and the week before, I needed a statement. I distinctly remember this because I was at a conference and I had to run to my hotel room, and I go on Google. I can't find it. I've learned a trick. If you want to get the real answer, if you want to know how old the Earth is, go to page 2 or 3 if it has any political content whatsoever.
So I appreciate that. It would be interesting to see specific details. The interesting thing is that we're talking now about two different things, each of which are quite important. One is what we might call the platforms, the things that really are hosting companies. You could also imagine things like WordPress, or sometimes like domain name registrars might be similar. I will say my quick search suggests, and maybe this is wrong, that according to Pew Research Center report, 20% of adults last year said they often get news via social media, 16% print newspapers. Television topped the list with 49% from TV, 26% radio, 33% newspaper websites. So when it comes to platforms, you can certainly envision a content neutrality regime. I'm not sure it's right for some of the reasons Eric mentions, but I'm inclined to say it would be constitutional for some of the reasons that Adam and Ann have mentioned. But at the same time, there's actually not that much at stake, because I don't think we're close to monopoly. For Google search, as I understand in the US, for search, Google search is over 90% of all the results. So there really is a tremendous amount at stake. I haven't seen that much evidence of overt sort of political manipulation by Google, but this is also an area that I think we all agree, you can't have a content neutrality rule. You probably can't even have a viewpoint neutrality rule in the strict sense. So if you do want to apply some sort of First Amendment or statutory rules to Google search, again, I think that there's First Amendment problems with it, just like there would be with regard to an encyclopedia. But even if there weren't, it would actually be really difficult to design a statute that prohibits improper selection criteria on Google's part, but allows those selection criteria that we think are really good. And simply saying disclose your algorithm, well, first of all, the algorithm, I think, is extraordinarily complicated. In some respects may have some properties, emergent properties, that may not be fully known to the authors, but beyond that also is actually, from a property rights perspective, tremendously important trade secret on Google's part. So you can imagine a disclosure regime. It's hard to imagine what kind of outright regulatory regime you could have for Google search without either itself becoming viewpoint-based, saying, oh, it's okay for you to exclude certain viewpoints or not other viewpoints, or becoming something that essentially saps search of all of the things we expect.
Professor Volk, if I could just respond, I take issue with that dichotomy. It's not as if we can say, oh, the only way we can regulate Google is saying you must be content neutral. I agree that doesn't really make sense given the fact what Google does. But you can say you can't be discriminatory. I mean, the Wall Street Journal was just today was about how, certain, there are blacklists on Google and things like that. Now, if that's the case, then that has to be disclosed. And I think it's very reasonable and perfectly consistent with, the 200 years of our law to say you can't do that.
Well, but wait a minute. Okay, so set aside disclosure. It's an interesting question, raises again trade secret questions, but I agree that would be a lesser sort of regulation. But imagine you had even a viewpoint neutrality regulation. I do a search on Google, and let's say I ask, should I vaccinate my child? Now, I do think that anti-vax positions ought to be protected by the First Amendment. But at the same time, if I'm a Google user, presumably I would like to have reliable information. A true viewpoint neutrality regime means that Google can't select for what it has good reason to think is the more reliable information, which is, again, the very information that its customers want. It would have to have an algorithm that if somebody sets up some sort of search engine optimization that puts all the anti-vax stuff up at the very top, or not even should I vaccinate, but what's the cure for X? And somebody has some weird arsenic cure for it or something like that, it would have to put it up there. Again, is that what we really want from search?
Yes, that's exactly the underlying point of the First Amendment, that the truth will emerge. They're not anti-vaxxers. Sorry if you're in the audience. And then there are a lot more people saying these people are nuts. I mean, it's the whole point of the First Amendment. You allow speech to counter speech. And if I could just say quickly,
Please.
I do not believe that poll. Number one, the average age of the Fox News and MSNBC and CNN viewers is 64. Those people are dying off. Anyone who claims to get most of their news from TV is in a nursing home. People who claim to be getting their news from newspapers, I think they're talking about reading the newspapers online. I mean, I just found out Miami Herald is about to go under. Kansas City Star is about to go under. Actual hold in your hand newspapers, I don't know, maybe they're popular at the nursing homes. So when people say they're getting their news from newspapers, I think they're saying they're reading a newspaper online. And how did they get it? Through Google.
Yeah, and the Google, I mean, as far as hard evidence, Google has been in Brussels and Luxembourg for years and years and years, and we have hard data. They dominate over 2/3, 80%, 90% in Europe of search market is Google, much harder data than what Pew gets from its surveys.
Oh, Google search? No. I totally agree that for Google search, it has this highly dominant position. But that we don't disagree on.
Professor Goldman, it looks like you wanted to break in.
I did want to answer the question that the audience member asked, but I do have to. I do want to get back to Professor Candube's point, though, that search engines should not discriminate. As I mentioned, all publication decisions are inherently discriminatory. They preference certain things and they prioritize others. So there is no such thing as a discriminatory search engine. That is a null set. That simply could not exist.
But that's like saying
that's not what
there is
he
no
said.
non-discriminatory job search. Yes, you're right. You want to choose the right person, but that doesn't mean that we can't take out certain considerations like race, like sex from that search. Yes, all job searches, you discriminate. I like this one, I don't like that one. But that doesn't mean that certain motives or certain ideas can't guide that discrimination. In fact, that's what AI is doing right now because they don't like what the algorithms are giving them. And so they're actually learning how to de-discriminate machine learning. I mean,
Do you think that could apply more broadly than banning a ban on particular content? Do you see a more nuanced way, in your view, that could be carried out by the companies?
Well, I would hope so. Yes, I mean certainly certain kinds of speech, like political discrimination. I think that we can put a very big magnifying glass on and actually demand greater disclosure. As far as knitting, like you seem to be so interested in, Professor.
Don't mess with knitters. Do not mess with those knitters.
Or anti-vax. I mean, I'm less concerned. But again, getting back to I think the comments that Anne so forcefully and correctly made is that if you're talking about the basic engine of the marketplace of ideas, extra scrutiny is totally okay.
What I would propose is that, as you could tell, the term discrimination here in this context is constantly changing its meaning. And we need to be rigorous about exactly which discrimination, why that's a problem, how that's different from the ordinary discrimination that's inherent in the publication process. And if, in fact, we even think that there's some reason that we could regulate that in light of the freedom of the press. That we
Viewpoint. Same as the First Amendment.
There's plenty of
That's
publishers.
the only thing you don't want. I don't know what the algorithm is that makes Google so good, but my guess is they look at how many people read a certain site, how long people spend on a certain site, whether it's linked to other responsible sites, that sort of thing, or other well-read sites. But that isn't, we disagree with this person's point of view. That's the only discrimination I'm talking about. Adam can get into other examples of where we do prohibit even speech that's discriminatory. All I care about is viewpoint discrimination, because that's the whole idea of the First Amendment, that the correct ideas will come out, but not with Google and Facebook and Twitter saying, oh no, you can't have the opinion that a man can't become a woman. You cannot misgender someone. And that's viewpoint discrimination.
So again, I think viewpoint discrimination doesn't actually answer your question. So for example, if we were ban viewpoint discrimination, we would allow all the different types of terrorist organizations to have equal treatment as the people that they oppose.
Correct. Unless they're committing a crime by, describing how to build a bomb. How do I know that? Because the First Amendment already says that. We don't need to invent the wheel.
I think the government has taken a different view on that very same question, that they in fact have required the removal of terrorist content that is in fact protected by the First Amendment because they have made a choice about the viewpoint that terrorism is a threat to our society and that we as a society are prepared to fight that threat to us. So I think that even the notion that we can be more precise or accurate by simply saying we're only going to ban viewpoint discrimination, I actually don't think we really mean that. You might.
No, but
we as a
viewpoint
collective-
within the world of what is First Amendment protected speech. That's what I'm talking about. So no, not obscenity, not describing how to molest a child or build a bomb. Those are crimes. But we already have that law. That's why I'm saying libertarians don't need to get freaked out about the FCC getting involved. We're just going to apply First Amendment law because this is the equivalent of a public square.
I'm sorry, libertarians, if you're not freaked out, you should be, because that's saying we are going to tell you how you can use your private property. That's not.
Eric. Yeah, but the law often does that. I mean, maybe in a perfect libertarian world it wouldn't, but we are in a world where the law does restrict private property in all sorts of ways.
I understand. I'm just saying that the libertarians oppose that.
Well, right. Well, they really pure libertarians.
Freedom of speech for this commenter right here.
Yes, exactly.
If we go fast, we may be able to fit in 2 questions. So I'll ask you for a brief question and we'll move on from there.
Sure. Thank you very much. This is actually one of my favorite topics here, viewpoint discrimination. And this goes right into the segue of media conglomerate. And I want to direct this question to Ms. Ann Coulter there. I believe she's an expert on this topic.
Remember, we're keeping it brief.
We have a president that is very expressive in the media realm, but yet we have a media that acts with double standards, say one thing and do another. And we have a conservative reality, we have a libertarian reality, and we have a liberal reality, and they don't treat each other as equals. You made up the point about Michelle Malkin, and she has expressed a certain of her public opinions in the media outlet, and yet she was being just punished. I mean, to the max, on the issue of Sharia law. And I want to see if you could give us some perspective and share some insights on that in terms of in regards to the debate that you guys currently were having. Thank you very much.
Well, the one thing I can say is just to elaborate on what I said. I mean, it's been shocking having these Google employees, and it hasn't been shocking to the people who are the victims of it. I mean, a lot of conservative websites, probably a lot of your favorite conservative websites, used to be making a lot of money online. They post a story, gets a lot of hits, they have ads there. Google, Twitter, Facebook, take it down. Oh, and by the way, they'll usually come back 3 weeks later when the story's over. And say, oh yeah, we're sorry, we made a mistake. I anticipate that this will happen next year during an election year. We're all going to be thrown off Facebook and Twitter, and once the election is over, they'll say, oh, I'm sorry, that was just a glitch, don't know how that happened. And she was one of the people, along with Daily Caller, Breitbart, where no, these people are blacklisted. We're going to lower their Twitter followers or Facebook hits. Yeah, they can go in and do that. And coincidentally, it's always conservatives. In the case of Milo, Gavin, and others, they're some of the most absolutely popular, and especially popular with young people, right-wingers. Coincidentally, they're gone. No, if you're dull, if you have no followers, if you couldn't convince, your mother, no, you're fine on Twitter.
Last but not least.
Hi. First of all, I'd like to say that you brought the really important question of down with knitting videos to the forefront. So I appreciate that. And I'm 51 and I don't read newspapers. But you brought up, there's a lot of discussion within this whole zone of the old fairness doctrine and the parade of horribles that came from that, in that it really did end up with people being suppressed because entities didn't want to comply with that. But I'm wondering if this can be thought about differently, because in those old broadcast mediums, they were constrained by time and space. In other words, a broadcast entity only had 24 hours a day. So one of the reasons why they wouldn't publish didn't want that fairness doctrine is because it ate into their time that they had available. The same thing with an actual physical newspaper or a publisher in that respect. And the internet's just different. There are no time and space constraints. So I would think that would play something similar to a fairness doctrine would play much differently.
Yeah, if I could just say one point, I think a lot of this discussion, loses the nature of the internet or the social network platforms, which is they're a bunch of private networks. And if you don't want to talk to Gavin, you don't follow Gavin. If you don't want to talk to Michelle Malkin, you don't follow her. People can make their own choices, and that's what I want them to do. And sometimes that would require having people make the choices with some law and regulations to protect them, and not Zuckerberg or Dorsey.
Well, thank you all. This was obviously a very vigorous discussion.